Rob Warlow from Business Loan Services, and welcome again to another edition of the Business Finance Bulletin Xtra. I'm delighted to welcome on the show today Spencer Laymond from Curwens Law, head of the commercial department. So welcome, Spencer, and thanks very much for sparing some time today.
Thank you, Rob. Nice to be on the call.
Yeah, great. Now, one of the reasons I called you to see if you want to share some of your insights today is particularly around the topic of contracts. But before we go into that, just give us a quick background to who you are, what you do, and what your kind of key responsibilities in Curwens is.
Fine, no problem, Rob. So I am what's known as a business lawyer or a company commercial lawyer. So my focus very much is about doing all manner of contracts on all sorts of situations. So it might be transactional, buying or selling a business, entering in joint ventures. It might be advisory, advising on terms and conditions, licensing intellectual property. I'm a solicitor, qualified originally as a barrister, cross-qualified shortly thereafter. I have about 20 years experience. I ran my own law firm for 6 years. About 3.5 years ago, I merged in with Curwens, and I head up the commercial departments, and we're about a 23 fee earner practice with offices in Enfield, Hoddesdon and Royston. Okay,
well, good stuff. So you're one of the rare people who made a transition of, say, starting your own firm and then moving into a bigger firm. So a big transition.
Well, I've kind of worked in very big super firms in the distant past when I was training, and gradually got a little bit smaller. Being running your own practice on your own was probably a bit too small, so sort of stepping back up again.
Yeah, well, good stuff. Excellent. Well, thanks for that, Spencer. Now, as I said, the reason I wanted to have a chat with you, because I know your specialism is about commercial law, particularly around contracts. Now, as we're recording this at the moment, clearly we're in what people are calling, and there's this phrase we're hearing all the time now, unprecedented times in terms of the coronavirus. And I was interested to kind of get your insights on contracts and the impact that the coronavirus is having in terms of the contracts that businesses are entering into. I'm often having conversations with business owners where I'm kind of regretting in a way that they've entered into some kind of contracts and are wondering exactly where they stand. So I just thought it would be useful to get your kind of insights. So what are you seeing now as the common situations that are arising out of the current issues that we're facing?
Okay. I can get straight into that, because obviously the big sort of headlines are the sort of the squeeze that's happening, the cash squeeze, the resource squeeze. It might be helpful just to take a very quick, just depending on when people look at this and listen, a step back to say to the viewers where we are in the situation. So as at today's date, the 29th of April, you know, we're obviously very early stage in the situation. We had the outbreak end of 2019, and very quickly in 2020 we've gone from a public health emergency to a pandemic to a lockdown in the UK for around 5 weeks. And we've had numerous businesses that have been closed, 4 million odd people on furlough. We've got a UK recession, and actually I was looking at the Bank of England monetary policy. One of their statements is early indicators that we're experiencing an economic contraction that's faster and deeper than anything we've seen in the past century, or possibly several centuries. So yeah, I don't mean to start off on a low, but it's that there is a lot of pressure because of what's happened. And, you know, the thing that's been in the news most of all has been this cash flow pressure, where if you're a supplier and you're not being paid, you're at one end of the scale, and then on the other end of the scale, if you're buying in services or goods and you're selling them down the line, and then you're not being paid, you've got this sort of vicious cycle going round. You've got the cash pressure, you've got the resource pressure. People just aren't available to be able to provide services either completely or on time, as you would expect based on the original contractual terms. And you know, it's you know, we hear this phrase continuity planning. That is the kind of rage for obvious reasons.
Yeah, I mean, it's clear the conversations similarly I'm having with business owners. Yeah, cash flow is clearly the major problem. I mean, whenever you look at top 3 concerns and pressures that business owners have, it's often cash flow. But obviously, this has been really exacerbated the problem. And of course, yeah, cash flow kind of underpins the kind of, I guess, legal and moral contract that many people have with their suppliers, for example. And yeah, it's interesting that you tie it into resources as well. So yeah, I mean, we are really in these times. I think I'm reading the figure that the GDP is expected to contract by about 35%, which is absolutely a horrendous figure. And I guess this is now where contracts can help you and I guess hinder you as well, as we perhaps start to come out of this, hopefully over the next couple of months.
Well, maybe. I think there's one thing coming out of it in terms of easing up on lockdown, but until we're actually properly through the situation, with vaccine and drug treatment, and we know what the sort of social responses are, actually this situation may just be the end of the beginning, but the start of something that could be quite a lot more going forward. And actually the idea of, your business contracts, what they say, take on a whole new meaning, because rather than just deferring these what if scenarios, what if this, what if that, actually now it's so relevant, and you can't ignore issues that sometimes just were secondary.
Yeah. So what kind of common contracts are now, do you think business owners are going to be looking at closely as to whether they actually protect them or end up to be in the proverbial albatross around their neck? What are you seeing on kind of common issues coming out now of these contracts?
Okay, so at the moment, I would say we're still quite early stages. I've noticed, looking at some of my peers, some of my colleagues, it's almost like a tsunami of, we've had loads of questions on this and hundreds of questions on that. And I'm thinking, actually, there's probably a lot of questions coming through, but the level of sort of information that's coming out, I think, is almost too much. Certainly I can tell you from my own experience with my own book of work that I was dealing with, the sort of traditional transactional stuff, like we're buying a business, or we're going into a joint venture, or we need to review this contract to make sure it's correct. That sort of stuff, I hate the expression, but has practically been mothballed. Very, very quickly, though I've had a number of inquiries that have come through to say things like, I don't have a problem yet, but actually I think I may have a problem, so what are my rights? So for example, if someone is involved in a joint venture or an acquisition, and there may be a number of steps to go, there may be some hurdles that set the price. It might now be a bad deal. What happens if my business partner isn't able to deliver? So what are my rights generally? Clearly, we've had questions that have come in relating to the cash flow problem, and it's either I can't pay or I'm not going to be paid. So what happens? I've had questions relating to a business divorce. So you have your regular home divorce, but actually when partners in a business don't get on or they can't work together, that's exacerbated. I've had someone inquire about whether it's appropriate to be a company director now, and what are the implications on things like wrongful trading, as well as just the sort of smaller, lower level questions like, how do we sign off on a document? I don't actually want to go out and have someone witness my document and catch an infection.
Go back to the common problem currently about cash flow and contracts that suppliers will have written with their customers. Obviously, your clients could be at one end, either they're a supplier or the buyer. Let's look at what can happen on both ends of that. So let's look if you're the supplier and your client is trying to renege on the contract, either in terms of accepting delivery of goods or having already received the goods is refusing to pay. So what are your rights as the supplier in either of those two situations?
That's quite a wide question. It would depend on what your contract provides, and in general terms, you and if your contract was silent, you'd look to see what what the common law says, and you have the Sale and Supply of Goods Act, Sale of Goods Act, which we could look at. But essentially, in a supply chain, you typically have contracts which are more often than not, unless it's a very high valued item that's a high valued service that's quite unique and bespoke, that might be negotiated. More often you have a standard form contract. And if you're a supplier, this is your standard terms of sale. So you would have a contract that would be in your favour as a supplier and not so favourable to your customer. And you would make things like time for delivery estimates. You would give yourself some buffers so that if there were problems, you would be able to excuse yourself from delivery being late. We can talk about force majeure, but you're likely to have a force majeure clause in the contract, and maybe even early termination rights, just as a sort of blanket exit. Whereas if you're the customer in that type of situation, and you were negotiating the contract, and the contract was drafted in your favour, it would almost be like the reverse provisions. If supply was going to be late, then that would be a material default entitling you to immediate remedies. It may entitle you to treat the contract as a material breach, entitling you to terminate the contract, to be able to appoint another supplier, whatever the cost, and then charge that back up the line. It really depends.
Yeah, you mentioned force majeure there. That's an interesting legal term that often hear banding around. Just talk about that briefly and what rights that gives people.
So force majeure and also frustration, they're the two keywords that are being used at the moment. And often clients will talk about, the contract's frustrated because of the coronavirus, or we can rely on force majeure. So we need to sort of treat each concept separately. And if we talk about, first of all, force majeure, and then we can look at frustration, because they are very separate concepts. Force majeure is really just a term of a contract. It's nothing more, nothing less. And it's given its name because of the background to how it was created. But essentially, it's a clause in a contract that says that when you enter into this contract, if something happens that's a problem later down the line, and it's beyond our control, then we have an excuse. We don't have to perform. We can bring the contract to an end. That's the kind of headline concept of a force majeure clause.
Okay, so I guess the other party would try and have that excluded from a contract if possible, because as you said, it's really a kind of a catch-all that allows me to get out of it. Or is it a standard clause you would see in all contracts, regardless of how strong your negotiating position is?
It really depends on contract to contract. So quite often you would find some type of force majeure clause. And when we talked about the fact that contracts might be favourable for a supplier or a customer, and actually, if an event happens and a supplier can't perform, in actual fact, performance is never, the condition of the contract. It's not a material term. I mean, that is almost like a limitation of liability clause. And there might be a number of other limitation of liability clauses in a contract, such as, look, if we've got it wrong and we can't perform and you have a right to sue us, the maximum we can be sued for is going to be set at a certain amount. So these are all limitations, and force majeure, if you like, is just another one of, in the armory, weapons that limit liability. It doesn't even have to be labelled as force majeure. It's just any clause that talks about the concept of if we can't do what we've contracted to do because some event happens beyond our control, then we should be excused. And it might be as simple as a one line. I've seen force majeure type clauses and it's just one sentence, whereas you can have force majeure that can go on for a good couple of pages where you set out a lot more detail and a lot more regulation as to exactly when you can rely on force majeure.
Okay. What about in times like this? Now, obviously, many businesses will have had long established relationships and very much been trading on trust. Now, trust can often be, really put to the test in times like this. What if somebody hasn't got any kind of formal contract? On the basis of the historic law, which is always say, well, if you don't have anything in writing, you're covered to this degree. Is there anything like that available to protect people?
That's a very good question. If you've got a long-standing relationship, I would be surprised if there wasn't at some point some terms and conditions that were written down. It does happen, but more often, certainly in my experience, there are some terms and conditions that would have existed, and quite often you have terms and conditions that would have been used in the beginning, but then as the relationship develops and you have more and more orders, the subsequent orders then may not properly go through that contract formation process where the older terms weren't incorporated as you would expect, but actually you might be able to say through custom that they are still incorporated in any event. If we turn to your question, you don't have any terms at all, then clearly there will be implied terms under legislation. And, in terms of the term as to when you need to supply your services and goods, it will be based on a reasonable amount of time, which will be based on whatever the type of contract and situation is. It's difficult to give a specific.
So we were talking about force majeure, and you mentioned then about the other one about frustration, which you mentioned there as well. So let's talk about a little bit about that then, about how people can claim that a contract has been frustrated.
Okay, so frustration is, I think, a much harder concept to avail yourself of, and although it's being used quite casually, that we can just say the contract's frustrated. It is a lot harder to say. It's not a term of a contract at all. It's a legal doctrine. It's where the law will step in and provide protection to deal with either vulnerable situations, and there are a number of what we call vitiating concepts or vitiating factors, like misrepresentation, duress, mistake, and frustration is one of those vitiating factors.
Okay.
And if you can show that your contract has been frustrated, then the effect is it just kills the contract. It kills it automatically and it kills it immediately. There's no term to look at. But the bar is set really high to show that your contract has been frustrated. You can't just say it's frustrated because we've hit bad times. If you look at the case law, it's because you were providing maybe a service at a particular building. It had to be that building, and that building has been destroyed. So typically, if you had a war, and a bomb hits the building or a fire. That's very different. Here with coronavirus, infrastructure is still pretty much intact. It's just people are staying at home. If you have a contract for a specific person to provide a specific service and that person is incapacitated or dies, then the contract's going to be frustrated.
Right.
If you were supplying goods and services, say overseas, and it becomes illegal to now supply goods and services to that particular country, that's another example where the contract may be frustrated. It really is a situation where the contract has been made impossible to fulfill, or it's so radically different than what was in the minds of the parties at the time of entering into the contract. So the coronavirus, as I say, is a horrendous situation, but it's not impossible to continue to fulfill the contract. It's a bad deal.
So let's have a look. Let's turn to now where clearly a contract's not been delivered on by either side. What are our options now? We've obviously tried to have a civilized debate about it, but what happens if that relationship is completely broken? Let's look at the various options that people have to kind of pursue terms under the contract.
Well, I suppose the start point is if you are a business and you're looking to defer performance, defer delivery, defer payments, then really the best thing you can probably do, if it's a one-off situation, it's a one-off contract, as opposed to, right, it's the whole business as a whole. I think we can look at if your whole business is having problems, it's a different category. But if these are one-off contracts, the first thing to do is obviously just talk to the supply chain, just talk to the other side. I think silence is always going to put the concerns into anybody. Yeah. And certainly with the work that you do, lending, where banks want to know and lenders want to know, are they going to be paid the next instalment? And not hearing is not a very good sign. It's a very good indicator.
Yeah, you're right. I mean, it's one piece of advice I always give where people got into trouble as regards making commitments. Just don't go silent, because otherwise the other party will make up their own narrative. They will fill in the gaps themselves as to what's going on. So yes, it's the worst thing you can do, isn't it?
So see what you can arrange. Now there isn't. I don't have the wisdom of Solomon. I don't have universal solutions and magic wands that will just fix problems. But clearly, if you can't agree the so-called payment holiday where you just stop paying or stop performing, if you can agree a deferment, say for example with payment, it's not that you're not going to pay, you are going to pay, but you'll just pay a little bit later. So if you've got a 12-month subscription and you're month 1, month 2, let's see if we can reduce the next 3 months by half, 50%, or just cancel the payments, but take that would have been paid and stick it on the back end and just increase the next 6, 7, 8 payments to see if you can negotiate some type of deferral.
Again, I guess in these current times we've got to be quite sensible as regards what's achievable out of a negotiation. I mean, both sides have got to accept that it's not easy times, and I suppose both sides need to calm down and come to to a negotiated settlement on any contract. And I suppose a review or a renewal of the terms would be appropriate as well.
I wouldn't. Yeah, I mean, if you're agreeing something which is quite straightforward as a deferment, I don't think you would necessarily want to get too excited on how you agree the variation. Probably an exchange of letters, an exchange of emails may be appropriate. Some types of contracts that are executed as deeds, for example, leases, and contracts of high value financial documents, yes, you might need some formality if you want the certainty that whatever you agree is binding.
So I guess from your point of view, the earlier you would get involved in negotiations and discussions, the better, I guess, because I guess there's nothing worse from your point of view, picking up a badly drafted contract and trying to get a good resolution. So earlier the better for you in terms of, say, drawing up contracts.
Yeah, and I think it also varies lawyer to lawyer. I mean, my background very much is transactional. It's a company commercial lawyer, so I'm very much about getting contracts right from the start, rather than picking up a problem down the road and trying to put it under the microscope and looking at all the different, they should have done that, should have done this. For me, it's about getting it right from the offset, being your fence at the top of the hill rather than the ambulance at the bottom. And yes, so no, look, for me, my relationships I have with clients, that they're always better when you're at the start of a process.
Good stuff. Good. Well, we're coming to the end of our time, surely. What would you kind of your key messages that you would want to leave people with, Spencer, in terms of managing, drawing up, and negotiating on contracts? What would you say your key messages would be?
The key message would be to try and build some contract resilience and fitness. If you're not already familiar with the contract law creation and the key contract law terms and conditions that should go into a contract, definitely now is a really good time to sort of build up that, sounds a bit cheesy, but muscle. Do your contract law press ups, understand about, what are limitation of liability clauses, what are exclusion clauses, how to draft them. There is a lot of technical lawyer input that can be required, but it's worthwhile reviewing your contracts to make sure that they are, you might have stress tested your contracts when it came to GDPR, and everyone was telling us about, you've got to do this, you've got to do that, otherwise you can't even talk to your mailing list, and do these addendums. Then we had Brexit, and it was like a whole nother language, backstops, withdrawals, customs, and now it's coronavirus. So really now is an excellent time to think about being smart on contracts. If necessary, get them reviewed by a professional to make sure that they are appropriate for your situation, and think about the what ifs, because more than ever now, you think, oh, well, it's never going to happen. It can happen. And if it does, then where are you?
Spencer, that's been really, really, really useful. If somebody wants to get hold of you, how can we do that? What's your email address and web?
So the email address is spencer.laymond@Curwens, CURWENS.co.uk, or the switchboard 0208 363 4444. At the moment, I'm working from home, not in this glorious office behind me. So if you call into the office, the switchboard will put it through to the number, which is redirected back.
Yeah.
Just taking a leaf out my my book about being smart. One thing we should have done from the beginning was just given the disclaimer. Obviously, this is hopefully a helpful conversation for your listeners. And this isn't specific legal advice. These are sort of general principles, and that if you do have an actual specific problem, then definitely get your specific legal advice.
Yep. I shouldn't be just kind of surprised by a discllaimer from a lawyer here.
It's usually at the beginning, not at the end. But
we'll sort that out. I'll put the health warning on at the beginning of the interview as well. Hey, Spencer, really appreciate you taking time, and I realise we touched a lot there, and of course, very hard to be specific about issues. But you've given us some great general pointers about watching for the pitfalls when it comes to contracts. And I think the key message for me is certainly now about taking the opportunity to review contracts and terms, so we're kind of fit from that perspective to make sure we don't fall foul. Spencer, I really appreciate it. Thanks so much for taking the time out from the chat.
Lovely. Thank you, Rob. Nice to speak. We'll speak again. Thank you.
Bye, Spencer. Bye now.
Bye-bye.